With regard to social media, sometimes questions arise about the employee's right to free speech under the First Amendment, whether it's something that's posted or written about off-duty or on-duty. This section that we're going to cover here looks at the framework created by the United States Supreme Court with regard to public employees' First Amendment rights. And there's a few cases that we're going to look at that highlights really that legal framework or analysis that the United States Supreme Court has carved out with regard to First Amendment rights of public employees. Starting place, obviously, with the First Amendment is the amendment itself, and as you see, the amendment covers the freedom of speech along with the other rights enumerated within the right of establishment and respecting religion and also peaceful assembly. But the freedom of speech in the First Amendment and how it applies to public employees who may or may not be exercising that right properly in the workplace or are disciplined for saying things that they believe are protected under the First Amendment is what we're going to look at here. Taking this quote out of the 1983 United States Supreme Court case of Connick versus Myers, states, "For many years, the unchallenged dogma was that a public employee had no right to object to conditions placed upon the terms of employment, including those which restricted the exercise of constitutional rights." Just a little background on Connick versus Myers. It's a Supreme Court case where Sheila Myers was an assistant district attorney who was disciplined by her supervisor, the district attorney in Louisiana, and basically sent out a questionnaire amongst her workplace peers to ask questions about their treatment or their opinions of how the office was being run. She was further disciplined for that. She won at the trial court, won again at the Court of Appeals, but then lost in the United States Supreme Court. And we're going to see further down the road through some of these cases why that is. And also look at other cases, as I stated earlier, looking at the freedom of speech rights of public employees. The case that really set off the whole thing was in 1968, the Pickering versus Board of Education case. And Pickering versus Board of Education was, I guess, the seminal case in First Amendment rights. It involved a high school teacher by the name of Marvin Pickering. He sent a critical letter to the local newspaper regarding the Board of Education's use of monies or funds between academics and athletics. Marvin's letter kind of pointed to the fact that he believed that the Board of Education was favoring athletics over academics, and would every so often, or it seemed more times than not, at the time Marvin was writing the letter, the board was asking for more money from the citizens in the community to fund the school board, and he set off this letter. Because of the letter, he was terminated, and the reason why, the Board of Education said it impugned them. The court found that the teacher was speaking more as a citizen than an employee. Now, when I say the court, I mean the ultimate decision of the United States Supreme Court. Mr. Pickering lost in the lower courts, his state courts in Illinois, and took his case by appeal to the United States Supreme Court, where they found in his favor. They found that, again, he was speaking more as a citizen than an employee. In other words, when he wrote the letter, even though he had information from this and an interest in this as an employee, the letter itself overall was more of that of a citizen than an employee. And that's going to begin really the framework that starts here in the First Amendment cases. There's another quote out of Pickering. "Public employee has a constitutional right to comment on matters of public concern without the fear of reprisal from the government as the employer." Now again, going back to the previous slide, we talked about the court finding that he was speaking more as a citizen. Now they're also talking about him speaking on matters of public concern, and this is how things start to develop in this area, this idea of a citizen speaking on matters of public concern. This is taken from another Supreme Court case discussing the government's, as an employer, their ability to regulate speech of their employees as opposed to that of non-employees. The public employers cannot silence their employees simply because they disapprove of their speech. Doesn't mean you can come out and say whatever you want to say. Again, the Supreme Court is carving out this framework they started in Pickering, talking about him speaking as a citizen on a matter of public concern, and it starts to develop. I think what's important to note about this particular slide is that the government employer cannot suppress all speech of their employees. However, you obviously know you have to watch what you say. The Sixth Circuit Court of Appeals, Federal Court of Appeals, has a three-step process in analyzing the First Amendment rights of public employees. Now, it's important to note we're looking at the Sixth Circuit because they are the Federal Court of Appeals, which governs our district here in Michigan. The Sixth Circuit covers the state of Michigan, the state of Ohio, Kentucky, and Tennessee. All the lower district courts within those states ultimately would, if a case goes on appeal, would go up to the Sixth Circuit Court of Appeals. That's why it's important that we're looking at the Sixth Circuit. First part of that analysis starts with what we looked at in Connick versus Myers, that the employee must show that the speech touches on a matter of public concern. We're going to talk a little bit more about that idea of public concern. And also demonstrate that the interest in the speech outweighs the government's countervailing interest in promoting efficiency of the public service it provides as an employer. In other words, looking at a balancing test between the rights of the employee in their speech against that of the government employer's interest in promoting the efficiency of the service it is providing. Second part is the employee must show that the employer's adverse action would chill an ordinary person in the exercise of his First Amendment rights. In other words, take out of the context the employee, put them as a regular citizen. Would the conduct of the government as the employer on a regular citizen chill that person's exercise of his right? In other words, arrest them from doing what they want to do or what they want to say in terms of what they're speaking on. And again, you have to keep in mind, we're talking about speaking on matters of public concern. That is what would be protected. Not everything is going to be protected. And we'll look more at public concern in a few minutes, but you have to remember that. And thirdly, the employee must present sufficient evidence to create a genuine issue as to whether his speech was a substantial or motivating factor in the employer's decision to discipline or dismiss. So that's the three-step process that is conducted by the Sixth Circuit Court of Appeals. Now we're talking again about matters of public concern. And I told you that was one of the things that was developed out of the Pickering case. Pickering found that, the Pickering court, I should say, found that Marvin Pickering, even though he was a teacher in that school district, when he wrote the letter as a citizen more than he did as an employee, but he also wrote the letter on a matter of public concern that would involve members of the community and touch upon their interests as far as what was going on with the school board, how they were using the money that was being provided to them. Here's a quote out of Connick as well. When a public employee speaks not as a citizen upon matters of public concern, but instead as an employee upon matters not only of a personal interest, his speech is not afforded constitutional protection. We talked about the speaking as a citizen on matters of public concern. Here, what Connick is saying is that when the public employee is talking about things not as a citizen, even though they may be of public concern, but they're speaking as an employee, they're not going to get that constitutional protection. And again, going back to the facts of Connick, the Assistant District Attorney Sheila Myers wrote the questionnaire out and submitted it to employees only. In other words, she wasn't really acting as a citizen, she was more or less a disgruntled employee of the prosecutor's office or district attorney's office there in Louisiana. Whether speech addresses a matter of public concern is determined by the record as a whole. Now, in the Myers case also, they talked about matters of public concern, and I can tell you it's not on the slide here, but they came up with this idea that speech involves a matter of public concern if it can be fairly considered as relating to any matter of political, social, or other concern to the community. And in addition to that, it is to be determined by the record as a whole. The court must consider the content, the form, and the context of the statement. All of those things are going to be important in looking at whether or not it is a matter of public concern. And also, again, keeping in mind in the broad context of all of this, does it touch upon matters of political, social, or other concern to the community? Think about the cases we've discussed. We talked about the Myers case where Sheila Myers disgruntled about some movement that's been created by the district attorney, shuffling her around to a place she doesn't want to be, sends out this questionnaire as a disgruntled employee, as opposed to Marvin Pickering, who's talking about the school board wanting to raise more taxes for the funding of schools. He writes this letter talking about how they allocate that money in favor of athletics over academics. So he's talking as a citizen, as the court found, on a matter of public concern, more so than what was found in Myers. There's a quote out of the Sixth Circuit case, Cherry v. Pickell. In the context of police departments, we have emphasized that the court should show deference to the city's judgment on the matter of discouraging public dissension within its safety forces. We've talked about the framework that the United States Supreme Court has created, talked about speaking as a citizen on a matter of public concern, and also the balancing of interests as well. The employee's right or interest in speech balanced against the government employer's right to basically provide its services, its whatever it is providing to the public efficiently. And this case here talks about that in terms of the balancing effect. It's also important to note that even if you do show that you're a citizen speaking on a matter of public concern, this balancing test is also going to come into play. Now we've talked about public concern, and we're going to turn our attention a little more to how a person was speaking, similar to that of the Myers case. But this case here, Garcetti, is most recent. It's a United States Supreme Court case in 2006, and it involves the Los Angeles County District Attorney's Office. A supervising district attorney, Richard Sabelos, was asked by a defense counsel, an attorney for a defendant, to review an affidavit for a search warrant. Supervising District Attorney Sabelos investigated the affidavit. He found that there were misrepresentations. Now this is his own finding, not an independent finding, but what he found. He spoke with the deputy involved in the affidavit. He relayed his findings to his supervisors, and he followed up with a disposition memorandum recommending dismissal of the case. Now there was a discussion between Mr. Sabelos and his supervisors and superiors, as well as those with the Sheriff's Department, and it was decided that they would proceed with the case, even though Mr. Sabelos felt that the case should be dismissed as written in his memorandum. The case proceeded. The counsel for the defendant filed a motion to dismiss the case. Sabelos was called as a witness by the defense to relay his observations as it related to the affidavit of the search warrant. The court ultimately denied the motion, and Sabellis then claimed as a result he was reassigned from his position as a supervising district attorney, transferred to another courthouse, and subsequently denied a promotion. The employer responded by saying that the claimed staffing levels that had a legitimate business reason for all of their actions had nothing to do with the fact that he had written this disposition memorandum in the particular case, and that even if it did, the memo was not protected speech under the First Amendment. So obviously, Mr. Sabellis files suit and claims that he was disciplined or adverse employment action was taken against him for his exercise of his First Amendment rights of free speech. The district court in his case held, and this is a federal district court, held that the memorandum was written in the course of employment and was not subject to First Amendment protections. The Ninth Circuit Court of Appeals reversed that decision. They cited Pickering in their decision, that the court held the allegations of wrongdoing in the memo constituted protected speech under the First Amendment right. The Ninth Circuit Court of Appeals seemed to focus their attention on the fact that the memo and the topic of the memorandum was inherently a matter of public concern. Well, what would that matter of public concern be? Mr. Sabellis was alleging misconduct on the part of the Los Angeles County Sheriff's Department in swearing out what he believed to be a false affidavit for a search warrant, or an affidavit that had serious misrepresentations on it which compromised the case. Now, that may be true, as stated. However, the Circuit Court of Appeals didn't look at that other aspect of what we were talking about in Pickering and how the Supreme Court has developed this, not only as a matter of public concern being a focus of the legal analysis in these First Amendment cases, but also in what role or what capacity was the speaker speaking? Was the employee speaking as an employee or as a citizen? And the United States Supreme Court certified this question before them in the Garcetti case, and the question was whether the First Amendment protects a government employee from discipline based on speech made pursuant to the employee's official duties. In other words, the way they frame the question right there tells you they're looking at the speech that he basically engaged in the memorandum of disposition. May have been a matter of public concern. That's not even talked about. What they're asking, though, in this question is he made it pursuant to his employees or as an official duty as an employee of the Los Angeles County District Attorney's Office, and should that be given First Amendment protection? We reject the notion that the First Amendment shields from discipline the expressions employees make pursuant to their professional duties. So there's your answer in the Garcetti case, is Mr. Sabellis, in writing the memorandum, which was what he was claiming to be protected speech, was writing that as an employee of the District Attorney's Office, not as a citizen, not as a concerned citizen on a matter of public concern. That's expressly what the slide states here, and what the court had basically held in that in deciding Garcetti, is that when you're talking as an employee, not as a citizen, you're not going to get the protection, the full protection of the First Amendment. Employees who make public statements outside the course of performing their official duties retain some possibility of First Amendment protection because that is the kind of activity engaged in by citizens who do not work for the government. In other words, the court really focuses in on that. Are they speaking as an employee, or are they speaking as a citizen? Public concern but employee duties. In Garcetti, again, Sabellis was talking about misconduct, serious misconduct on the part of a law enforcement agency that obviously would be a matter of public concern, but he was doing so as an employee. Next, we're going to look at the case, a recent case, 2015, decided by the Court of Appeals of the Fifth Circuit. Case is Garcetti versus City of Greenville, and this ties in a little more with our discussion in the social media section with the posting of Facebook or other social media networks where people voice their opinions on those off duty sometimes, and this case really examines that closely. Again, this is a case out of the Federal Court of Appeals in the Fifth Circuit, which covers the state of Mississippi. Sergeant Susan Garcetti was a 17-year veteran of the City of Greenville Police Department, and what she had done was made some comments on Facebook while she was off duty and on her home computer, and basically criticizing her police chief's decision not to pay for gas for department vehicles in order to send officers to the funeral of an officer who was killed in the line of duty in a neighboring Mississippi community. Her comments ultimately led to her termination. She filed a lawsuit in federal court alleging that adverse employment action had been taken against her in exercise of her free speech rights, and that the city terminated her, and she sued the city and the chief of police. Cut right to the chase and give you the decision, and after that we'll show you why and how the court decided this. They basically said that Sergeant Garcetti was speaking as a private citizen, and that they held that she was not speaking on a matter of public concern, though. And remember, that's the two aspects that we're looking at that came out of Pickering. Speaking as a citizen on a matter of public concern. Remember, in Garcetti, he was speaking on a matter of public concern, but not speaking as a citizen. He was speaking as an employee. Here, the Fifth Circuit, in their analysis of this case, says, yes, Sergeant Garcetti, you were talking as a citizen on this matter. However, it was not on a matter of public concern. Instead, the court held that Sergeant Garcetti, her posts on social media was a rant against the chief of police and similar to an internal grievance. So let's look at what Sergeant Garcetti was posting and saying. She originally posted this on her Facebook page, and basically is very critical of the chief of police's decision not to send officers to the funeral of the slain officer. I want you to focus in on the bottom of the slide. It says, "Thank you, Susan Garcetti." She does not put Sergeant Garcetti. She states Susan Garcetti in the post. And again, this is off duty on her own computer. She received several likes from friends on her Facebook post, and then goes on to again criticize the chief, calling into question his ability to lead. Although she's talking about issues within the department, again, she doesn't use Sergeant Garcetti. And I think that's important because the court ultimately did find that she was speaking as a citizen. She then took the initial Facebook post and put it on the City of Greenville Mayor's public Facebook page. Again, she received some likes because of her posts, and then ultimately stated in a post, "If you don't want to lead, can you just get the hell out of the way?" And then posted after that, "Seriously, if you don't want to lead, just go." Remember back to the discussion on public concern, we talked about what they're looking at, the court's looking at in analyzing the public concern, that a matter touching on political, social, or other concerns to the community has to be taken on the record as a whole, the content, the form, the context of the statements. And what the court in Garcetti ultimately found was that it wasn't a matter of public concern, that what you're looking at here and what her post said, previous post said, was a rant against the chief, her dissatisfaction with her police chief, and her belief and her opinion as a citizen. Granted, the court found that she was speaking as a citizen, that she felt he was not a good leader, and his decision not to gas up cars and send officers to a funeral for a officer who was killed in the line of duty, she felt highlighted this. However, it was not a matter of public concern as found by the court, and the termination was upheld. Again, speaking as a private citizen, but not public concern. Compare and contrast that with the Garcetti case, where Garcetti was speaking probably on a matter of public concern, but not as a private citizen, as he was speaking as an employee in writing the memorandum disposition. Go to Pickering. Pickering is writing a letter to a local newspaper criticizing the school board's constant solicitation of raising taxes for the purpose of dumping them into the schools. However, he's critical of how they use the funds and wants the public to know that. So ultimately in Pickering, they found he was speaking as a citizen on a matter of public concern, so he was able to prevail in that case. Garcetti and Graciosi are claims that were made under the First Amendment. These cases, Pickering as well, Connick versus Myers as well, these are people who are filing federal lawsuits claiming that adverse employment action was taken against them by their public employers, and they were taken against them in violation of their First Amendment claims and First Amendment rights. Now, a few things have to be said about this, because some people ask, well, what about other protections that I may have, protecting speech or conduct? And that is true. Under the Whistleblowers Protection Act, there's statutes or whistleblower statutes that protect conduct outside of that which is protected under the First Amendment claims, the claims that we looked at under these cases and the framework that we looked at under the United States Supreme Court in Pickering and what followed. So keep in mind that although speech or activity may not be protected under the First Amendment analysis, there may be other statutory protections out there that will provide protection other than what is claimed under the First Amendment claims. And one of those is the concerted activity, which you'll find under the Public Employment Relations Act, PARA, and that will be the next section that will be discussed.